On September 26, 2024, Iwao Hakamada, then 88 years old and recognized by Guinness World Records as the world's longest-serving death row inmate after 45 years waiting for execution, was acquitted of murder in a verdict that shook Japan. The case involved 4 victims, Hakamada's employer and his wife, along with their 2 children. On October 9th of the same year, prosecutors gave up their right to appeal, and the not guilty verdict officially took effect. Hakamada had spent 45 years in the death row cell block, never knowing which day might be his last. While he remained incarcerated, his older sister devoted more than 4 decades to filing petitions, gathering evidence, and demanding a retrial. At the retrial, the court determined that part of the key evidence in the case, the blood-stained set of clothing said to have been hidden in a miso fermentation tank, had been fabricated. The court also found that the statement records had been obtained in circumstances that violated the right to remain silent, creating a risk of a false confession. That became the foundation for why a death sentence that lasted nearly half a century ultimately collapsed.
Hello, and welcome back to Dark Crimes Real.
The Hakamada case was a robbery, murder, and arson attack that took place in June 1966 in Shimizu City, Shizuoka Prefecture, now Shimizu Ward, Shizuoka City, Japan. At the scene, the bodies of 4 members of the family of an executive at a company that produced and sold miso were found with multiple stab wounds, and the house had been completely burned down. According to the recorded timeline, in the early morning hours of June 30, the wooden home of the family connected to the miso company suddenly caught fire. The house was in a densely packed residential area, with neighboring homes almost pressed up against it. Between about 1:35 and 1:40 a.m., a neighbor heard unusual sounds like objects collapsing. By around 1:50 a.m., flames were seen erupting from the house. The fire spread extremely quickly, making it very difficult to get inside, and it was not brought under control until around 2:32 a.m. Parts of nearby houses were also burned. When the scene was examined afterward, authorities found that 4 victims had died inside the home. The victims were a family of 4. A, 41 years old at the time, his wife B, 38, their second daughter C, 17, a second-year student at Shizuoka Eiwa Girls Academy, and their son D, 14, a third-year student at Sodeshi Municipal Junior High School. At the time of the incident, A's father was hospitalized at Shimizu Kosei Hospital for rheumatism. A's mother, 61, A's eldest daughter, 19, and the family's live-in helper were sleeping in a private room next to the factory and therefore escaped the attack. Forensic examinations recorded that all 4 victims showed signs of being attacked with a sharp object. At the same time, 370,000 yen, about $2,300 out of roughly 500,000 yen in cash collected the day before, was still missing. These signs indicated that this was not a simple accidental fire, but a robbery, murder, arson case. The case quickly became a major priority file for the prefecture. A family of 4 was killed in a single night, the house was set on fire to erase evidence, and the scene was heavily affected by the flames and the firefighting effort, making it very difficult to preserve many physical traces in their original condition. At the time, Kogane miso was well known in the Kanto and Tokai regions, with a large annual output, making it the 3rd largest producer in Shizuoka Prefecture. The company's annual sales of miso and soy sauce remained high, and the business was doing well. The miso factory, run by A, was located about 30 meters south of A's house, on the other side of the Tokaido Main Line railway tracks. The Shimizu Police Station, under the Shizuoka Prefectural Police, worked together with the Prefectural Police Headquarters' First Investigation Division to carry out the investigation. At the scene, police seized a raincoat and a knife believed to be the murder weapon. On July 4th, Shimizu police searched the miso soy sauce factory and the workers' housing on the factory grounds. In Hakamada's room, he was 30 at the time and an employee of the company, they seized a set of pajamas with bloodstains. Shortly afterward, Hakamada was placed under investigation, not only because of the evidence found in his room, but also because of his reputation as a former professional boxer, seen as someone capable of taking down the company executive, a large man who was also a black belt judoka. At the time of the incident, Hakamada was living in the dormitory on the factory's second floor. Iwao Hakamada was born on March 10, 1936, in Yuto, Shizuoka Prefecture, now part of Chuoku, Hamamatsu. He had been a professional boxer before leaving the ring. After retiring, Hakamada opened a bar in Shimizu City, but it did not last long and soon closed. During this period, he married and had a son, then divorced his wife after the bar shut down. After that, he worked at this company. At around 6:40 a.m. on August 18, 1966, Hakamada was summoned to the Shimizu police station for questioning, and by 7:32 p.m. that same day, an arrest warrant was executed on suspicion of robbery, murder, and arson of a residence. In addition to those charges, the arrest allegations also included theft from the products from the factory. On August 21st, Hakamada was detained at the Shimizu police station. By September 6, 1966, Hakamada began to confess. In his confession, he stated that he had decided to commit the crime on the night of June 29th and waited in the employee's dormitory. At around 1:20 a.m. on the 30th, he said he put on his pajamas and the factory's raincoat and went to A's house, located across Tokaido Road from the factory. A, who was asleep, noticed him and screamed, and after a struggle, he said he stabbed A to death with a pocket knife he had brought with him. He then killed B, C, and D, who had been awakened by A's scream, and thought that if he set the house on fire, there would be no evidence left. On September 9th, the same day his detention period was set to expire, the Shizuoka District Public Prosecutor's Office indicted Hakamada for breaking and entering, robbery, and murder and arson, while the remaining theft charge was not prosecuted. However, in court, Iwao Hakamada recanted his statement and denied all charges. In Hakamada's initial explanation, the blood on his pajamas did not come from committing the crime. He said he cut his finger while taking part in firefighting and rescue efforts after the fire alarm sounded, and that the blood got on his clothes at that time. He also said the injury happened in the chaos, so he didn't clearly notice exactly when he was cut. He maintained that the statements he had signed during the investigation were not made of his own free will. As a result, the question became what conditions produced that confession and whether it could serve as a foundation for conviction. From that point on, the interrogation process became one of the central points of controversy. In addition, even after he had confessed, the creation of confession records continued at a heavy pace. Compiled sources report that 45 confession statements were produced. In just the first few days after he began admitting guilt, the number of written statements rose rapidly, and they continued to be created even after he had already been indicted. Detention records describe Hakamada's interrogations as extremely harsh. Questioning continued over 19 consecutive days, averaging about 12 hours per day under scorching heat, with a maximum of up to 17 hours. Compiled materials claim he was repeatedly subjected to mental and physical abuse, with no drinking water or access to a restroom. He was also forced to urinate in front of his interrogators by having a portable toilet brought into the interrogation room. One notable point is that questioning after 10 p.m. took place almost daily, with no indication that time was made up by allowing rest or starting later the next day. Even when he was asleep, he was kept in a room next to a drunken man who deliberately shouted loudly, preventing him from sleeping. As the end of the detention period approached, the interrogations became even harsher, and Hakamada only began confessing 3 days before the deadline. The number of detectives assigned to interrogate him also increased from the initial 3 or 4 to nearly 10. These illegal acts were said to have been carried out by officers trained by Shizuoka Prefectural Police Inspector Kurebayashi Asao. Shizuoka had long carried a reputation for wrongful convictions linked to interrogation practices built around coercion. During this period, access to counsel was strictly limited. According to a summary by the Japan Federation of Bar Associations, the total time Hakamada was allowed to meet with his lawyer during that span was only about 30 minutes. During the same period, Hakamada wrote a letter to his family stating that he was absolutely not the perpetrator. For that reason, in later court proceedings, the dispute was not limited to the question of whether he had confessed, but rather under what conditions that confession was produced, and whether it was reliable enough to support a death sentence. In fact, official materials released later acknowledged that the interrogation methods at the time drew heavy criticism. A report by the Shizuoka Prefectural Police, published after the retrial ruling, also stated that the court found the interrogations had a coercive, threatening effect on the suspect's free will. And during the retrial, new details, stemming from interrogation recordings discovered in the course of the retrial proceedings, made those criticisms even sharper. Once the confession appeared, the prosecution file had its first pieces of evidence. But in a case involving 4 deaths, a confession alone was still not enough to lock in a verdict, especially with the controversy surrounding coercive interrogation. The investigation needed something more concrete. And that was when the case's second piece of evidence emerged, a set of physical items discovered later. About a year after the fire, when the case was already in the litigation stage and the confession had become the focal point of dispute, the file suddenly gained a new missing piece. At the factory, in a miso fermentation tank, employees found a sack. Inside were 5 items of clothing stained with blood. From that point on, the direction of the prosecution's case began to shift. If earlier investigators had focused on the traces found on the pajamas and related details, prosecutors now treated the 5 items of clothing as something that could directly establish guilt. Prosecutors argued these were the clothes the killer wore during the attack, while the pajamas were what the defendant changed into afterward. The problem is that this evidence did not simply add to the file. It reshaped the entire structure of the prosecution's narrative. Now the prosecution had 2 pillars of incriminating evidence. The first was the set of interview records created during the investigation bearing the defendant's signature. The second was the 5 blood-stained clothing items said to have been found in the factory's miso fermentation tank. Prosecutors laid out a straightforward logic. The killer attacked with a knife, the clothing became stained with blood, and then the killer tried to dispose of it by hiding it in a place that would be hard to access. A miso fermentation tank, sealed with a lid and used for long fermentation periods, was portrayed as an ideal place to bury evidence. Under this argument, the 5 items of clothing were not just traces, they also became an explanation for several points that had been unclear in earlier accusations. But from this point, the defense began pressing a different question. How long had those 5 items of clothing been inside the miso tank? In the record, A miso fermentation tank was not a place outsiders could freely handle. The factory had its own procedures and controls. According to accounts related to the initial searches, investigators did check the factory area, but the extent of their inspection of the tanks was limited by practical conditions: heavy lids, thick fermenting contents, and the inability to stir and search everything the way one might search an empty room. That limitation created a gap that both sides tried to use. Prosecutors argued that because the tanks were difficult to inspect, evidence could have been missed. The defense countered that if the tanks were difficult to handle, then the question of how the evidence was placed there at the right time was precisely what should raise suspicion. From a single piece of physical evidence, the dispute opened into multiple contested issues. The first issue was timing and the plausibility of such a late discovery. A major case with 4 victims typically triggers repeated searches and rechecks, so the appearance of a crucial piece of evidence a full year later led the defense to question the reliability of the chain of custody and the evidence's origin. The second issue was whether the evidence fit, specifically the 5 items of clothing. In disputes recounted in various materials, there is the detail that the defendant was asked to try them on, and the result was that the clothes did not fit. Prosecutors explained this by suggesting shrinkage caused by the fermentation environment, or changes in body size over time. The defense viewed it as a sign the clothes did not belong to the defendant from the outset. Whichever side one takes, it was a point that made the evidence appear fragile. The third issue was the condition of the bloodstains. Even if one of the items had blood type testing that matched the suspect's blood type, that still could not prove he was the perpetrator. In addition, if the evidence had truly been kept in a long-term fermentation environment, it raised obvious questions. How should stains change over time, and why would the blood remain dark after a year in a miso tank? This became the basis for later arguments, including experiments and scientific analyses introduced during retrial proceedings decades later. At the earlier stage, however, conclusions could not be reached using DNA testing the way they can today. Finally, there was the decisive question: did those 5 items of clothing actually belong to the defendant? Prosecutors tried to tie them to Hakamada through indirect details, such as witness claims that they had seen him wearing similar clothing. The defense emphasized that similar does not mean his, and that in a death penalty case, the link between evidence and the accused must be far clearer and more direct. The discovery of this new evidence became a turning point that shifted the entire game. It gave the prosecution a stronger narrative, but it also gave the defense grounds to argue that the case was being constructed from things that appeared only later. As a result, the trial became a tug-of-war over the standard of proof. Those rebuttals could not be closed with a single round of arguments, but they created a clear fracture. The 2 pillars of the prosecution's case could no longer stand on their own. They had to be continuously explained, justified, and defended in court. Even so, on September 11, 1968, the Shizuoka District Court found Hakamada guilty and sentenced him to death. After that, the case moved through the appellate process. The death sentence was ultimately upheld by the Supreme Court of Japan and became final in 1980. At that time, a panel of 3 judges ruled that Hakamada was guilty by a 2-to-1 vote. Kumamoto Norimichi was one of the 3 judges. During the trial, he did not believe there was sufficient evidence to convict Hakamada of murder. Looking at the evidence, there was almost nothing proving he was the killer besides the confession. But that confession was obtained after the defendant had been interrogated for a long time, Judge Kumamoto said. Kumamoto told the other 2 judges this, but they did not agree. I couldn't persuade the other 2 judges that Hakamada was innocent, so in the end we still had to find him guilty. I couldn't endure the torment of my conscience, so 6 months later I resigned, Judge Kumamoto said. After the death sentence was upheld, the case entered a long appeals phase, a procedural battle to reopen a conviction that was already final. The first bid for a retrial stretched on for years and ended in 2008 without success. Soon after, a second retrial effort was launched, filed by Hakamada's older sister. During this period, prosecutors continued releasing a large volume of documents, while the defense kept pressing arguments centered on the reliability of the confession and the 5 items of clothing evidence. His sister's efforts to win back her brother's freedom finally paid off. On March 27, 2014, the Shizuoka District Court agreed to reopen the case and grant a retrial. Among the grounds it considered, the defense cited forensic findings, including that DNA obtained from the bloodstains did not match Iwao Hakamada's DNA, raising serious doubts about the reliability of the physical evidence. The court ordered the suspension of the death sentence and halted his detention, and Hakamada was released the same day. But that decision did not immediately move the case into a retrial courtroom because prosecutors filed an objection right away. On June 11, 2018, the Tokyo High Court overturned the Shizuoka District Court's retrial decision. The defense then pursued a special appeal. After the matter was reconsidered, on March 13, 2023, the Tokyo High Court backed the 2014 retrial decision and rejected the prosecution's objection. Prosecutors did not take the final step of further appeal, which made the retrial order officially final. Once the retrial was locked in procedurally, the actual hearings could begin. According to summaries by bar associations and human rights groups, the retrial opened on October 27, 2023, ran for 15 sessions, and closed arguments on May 22, 2024. Prosecutors maintained their position and sought the maximum penalty, while the defense called for an acquittal. On September 26, 2024, the Shizuoka District Court found Iwao Hakamada not guilty in the retrial. The core of the ruling did not rest on a single detail, but on the court's conclusion that the evidence used to convict him was no longer reliable enough to sustain a conviction. In the published summary of the decision, the court identified 3 pieces of evidence it deemed to have been distorted, each directly tied to how the prosecution's case file was constructed. Once those 3 elements were removed, the remaining record was not sufficient to conclude that the defendant was the perpetrator. The first point concerned the confession statements used as evidence. The court examined the conditions under which the statements were produced and the credibility of the admissions in light of the fact that the defendant later withdrew them in court, criticizing the way the statements were obtained as creating a risk of a false confession. The second point was the set of physical evidence described as the 5 blood-stained items of clothing. The court analyzed the condition of the stains and factors related to the miso fermentation environment, rejected the claim that the evidence accurately reflected the crime, as the prosecution argued, and concluded that this evidence could not be regarded as reliable within the prosecution's chain of proof. The third point involved a piece of fabric seized at Hakamada's home, which was used to compare with the clothing in the 5 items, in an effort to show that those clothes belonged to him. According to the court, this was also a link that had been distorted and could not serve as a foundation for proof. The September 26, 2024 ruling would not have been the final word if prosecutors had continued to appeal. But on October 9, 2024, prosecutors announced they would not appeal, making the acquittal final and legally effective. After that, the relevant authorities released their responses one after another. Shizuoka Prefectural Police posted a fact verification report based on the retrial ruling, acknowledging the serious problems the court had pointed out and describing current improvement measures, such as standardizing interrogations and making audio and video recordings in certain cases. Senior prosecutors also published their own review report, sparking public debate about accountability and the standards used to oversee investigations in serious criminal cases. The verdict pointed out that investigators staged the 5 items of clothing. Prosecutors still have not acknowledged that this case involved a wrongful accusation, and they have not offered a sincere apology to Mr. Hakamada or shown any genuine remorse over what happened. Chief Prosecutor Naomi Unemoto explained the reason for abandoning an appeal was that she considered the fact that Mr. Hakamada Iwao had been placed in an unstable legal situation for a long period of time. However, she also expressed deep dissatisfaction with the acquittal, saying she was extremely dissatisfied with the decision declaring the conviction evidence to be fabricated. On March 24, 2025, the Shizuoka District Court awarded Hakamada compensation of about 217 million yen, about 1.4 million US dollars, the maximum amount permitted under the Criminal Compensation Act. This is believed to be the largest amount ever granted. Mr. Iwao Hakamada is now 89 years old. It has been 59 years since the crime occurred, 45 years since the sentence became legally final, and 11 years from the decision to grant a retrial to the point of reaching this acquittal. The fact that it took so long to correct a wrongful conviction clearly shows that Japan's retrial system is not functioning effectively, and that amending Part 4, Retrials, of the Code of Criminal Procedure is absolutely necessary. In particular, full disclosure of evidence in cases seeking retrial relief and a ban on prosecutors appealing decisions to begin a retrial need to be implemented as soon as possible. It has become a reference point in Japan's criminal justice debate, from interrogation practices and how confessions are evaluated to standards for managing and verifying physical evidence in cases with the harshest penalties. Moreover, Mr. Hakamada Iwao was haunted by the fear of execution for 34 years, from the time the death sentence was imposed until his detention was suspended, and he continues to suffer symptoms tied to imprisonment. The fact that the death sentence was not carried out does not mean Mr. Hakamada Iwao's suffering has ended. Executing an innocent person is no different from an extrajudicial killing, and there can be no greater injustice than that. To date, Japan has had 4 acquittals in death penalty retrials: the Menda case, the Saitagawa case, the Matsuyama case, and the Shimada case. That this acquittal, the 5th in a death penalty retrial, has now been completed raises serious questions about Japan's death penalty system. Death row inmates in Japan are often held in isolation and have limited contact with the outside world. Executions are carried out in secrecy, with little or no advance notice. Since 2000, Japan has executed 93 prisoners who were told about their hanging only a few hours or even a few minutes beforehand. Families and lawyers are often informed only after the execution has taken place. The most recent execution carried out in Japan was on June 27, 2025, involving the Twitter killer Takahiro Shirashi. In a personal level, Hakamada has been out of custody since 2014, when the court granted a retrial and suspended his detention. But the prolonged retrial process meant his condition has often been described as leaving him no longer fully able to take part in normal everyday life as before. Iwao Hakamada spent every day for 45 years thinking it might be his last. He endured an unimaginable ordeal, including more than 30 years in solitary confinement and under constant surveillance. Throughout that journey, his older sister was the one who stepped forward on the family's behalf to pursue legal procedures for many years, signing petitions, working with lawyers, and appearing in the media within what was necessary. This is a case in which a person was forced into a confession and evidence was staged. In reality, many of the issues seen in this case still exist in Japan's criminal justice system today, and Iwao's case is not an isolated one. According to a statistic from Japan's Ministry of Justice, retrials are extremely rare in this country. The fact that courts conduct retrials repeatedly has two sides. On one hand, it shows shortcomings in Japan's justice system. On the other hand, to ensure justice is truly carried out and that the truly right person is tried and punished for the right crime, retrials by the courts are still very necessary. Therefore, the biggest impact of this case is not only that one person was cleared, but that it forces the system to face a core question. In a death penalty case, when the record is built on statements and contested physical evidence, what standard is enough to convict, and what standard is too late to correct a mistake? To prevent the mistakes of the Hakamada case from being repeated, Japan is determined to do everything within its ability to amend retrial laws so that timely relief can be provided to victims of wrongful convictions, as well as to abolish the death penalty and suspend executions. In addition, acquitting Mr. Hakamada also means there is still no answer as to the true perpetrator, and the 1966 case remains unsolved.